Good afternoon and welcome back to the Public Service Commission as we continue in the hearing in docket number 2023-89-E. This docket concerns the petition for storm security and financing order filed by Duke Energy Progress. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, Chair Belser, and with us virtually we have Commissioner Irvin. Yes, sir. I see we have a. Do we have a matter we need to attend to?
We do, and they're both very brief, but we thought it would be helpful to come back and address them with you and the commissioners. We talked about the question about the bond advisory team and the membership to the bond advisory team. And since this was a matter agreed to in settlement, we thought this was something that was best if you heard from the lawyers for the respective parties as opposed to a witness that was not in the room. I'm prepared to address that, but also have you hear the other lawyers for DCA and ORS are also prepared to answer any questions or be heard on it as well. We think it would be brief, but and then we just had one other. I can stop there, but we do have another preliminary matter in terms of witness.
I see some heads nodding, so let's go ahead and hear from the attorneys on the bond advisory team. Thank
you very much. So just commissioners, very briefly on this, is we talked about, we have formal membership, and then we had, the DCA was invited. And as part of the discussions, it was raised from just a practical matter. In terms of staffing, in terms of budgets for the DCA, that having an invitation was more practical, because if you are a formal member, you must attend every single meeting or there cannot be a meeting. If you're an invited member, then you can attend every single meeting if you have that capability. If you don't have that capability, the meetings can still go forward. So it is the company's position this was a very pragmatic approach to allow participation, but also recognizing staffing level, budgets for consultants that were available. In doing that, it was also a compromise, because if you'll notice in the settlement, we noted, and it was put by all parties, it was put into the record that ORS is charged by law with the duty to represent the public interest of South Carolina pursuant to SC Code 58410B, which reads as pertinent parts. Public interest means the concerns of the using and consuming public with respect to public utility services, regardless of the class of customer, and preservation of continued investment in maintenance of utility facilities so as to provide reliable and high-quality utility services. And that was put in with the express acknowledgement by all parties that if ORS was sitting on the bond advisory team, they were doing so with this statutory charge, and this statutory charge was paramount to any other activities or role on the bond advisory team. So that's, from the company's perspective, how the parties arrived at this compromise solution.
Thank you, Mr. Cooper. Mr. Hall, I see you've risen.
Thank you, Madam Chair. Just to chime in, since this provision that y'all had questions about does relate to our role or as an official or a formal or informal member on the bond advisory team. And again, not to get too much into the settlement discussions, but we accepted the company's rationale for not making us a quote unquote formal member. To us, what was more important, and the language is in the settlement agreement, is that we will be invited to attend all meetings and we will be provided the same information that is provided to formal members.
Thank you, Mr. Hall. Officer of Regulatory Staff.
Hey, Madam Chair, just may I be heard very briefly?
Just a second, Mr. Huber. Nucor, any comment?
Chair Belzer, I don't have any comment on this issue.
Thank you, Mr. Lavonga. Now, Mr. Huber, I'm sorry.
Yes, and Mr. Cooper is correct. As part of settlement discussions, it was proposed that ORS act as QITP, and of course, we are subject to our statutory mission as part of that. If we were to serve in that role, it was understood and agreed we would act in accordance with our statutory mission and how we fulfill that role of QITP.
Thank you,
Thank you,
Mr.
Madam Chair.
Thank you, Mr. Huber. Any other comments on that issue from council?
None from the
Thank
company.
you.
Thank you.
Appreciate the explanation, but we do recognize, as you do too, that you are providing explanation and that is not testimony, so
Thank you very much.
thank you.
Wilson.
Mr. Cooper, you had another issue?
We do. We just have one more.
Madam Chair,
Commissioner Thomas?
I would like to ask a question. And this is directed to Mr. Hall. Quite simply, do you believe that customers are appropriately represented on the bond advisory team and members are unofficial members? Do you believe that that is the case?
Yes, I believe so, and I believe that we will have the same level of input as the ORS. Granted, we will not be providing a certification. That's understood. The statute provides for certain entities to provide a certification, but beyond that, we would certainly plan to attend every meeting that we are able to, and hopefully we will be able to attend all of them. There was some question about our consultant not being on there. We certainly plan to have a consultant assist us. Not be attending the meetings, but we certainly plan to be in discussions with folks that might have more expertise than we do.
Thank you. I appreciate that. That's all.
Thank you, Commissioner Thomas.
I'm sorry.
Mr. Cooper?
Thank you. Thank you, Chair. I just wanted to ask in terms of schedules and Witness Smith for the company. Witness Smith has obligations out of the country as part of a celebration later this week, and I am here with you because I told her there's no way we would be going on Wednesday, and so I'm therefore I know I'm just late, but I just wanted to give if we would take her out of turn.
That was
today,
why
make
I
her
asked
available.
that's why I asked the parties to consult
that-
over lunch,
and
because
that's-
I recognize that there are some scheduling issues for Wednesday, and we need to accommodate those.
And so we've taught, I just wanted to make the commission aware of the nature of her testimony to see, I don't know whether you just want us to put her up regardless, but she's really someone who talks more about the methodology, the calculation of quantifiable net benefits. So she's not one to talk about the policy. She's not one to talk about, what the components, but really she is the one to say, here's the methodology, here's the calculation that would be performed. In terms of deferrals, she's not talking about policy of whether deferrals are appropriate, but these are how we would calculate the deferrals. So her testimony is more on the lines of someone who's going to talk about the actual calculations as opposed to underlying policy, but we can make her available today if that, and we talked to the other parties about that, if that's acceptable to the commission.
Yes, we'll certainly take her out of order if we need to. Are you offering to stipulate her testimony in?
Can I have one moment, please?
Yes.
Thank you, Chair Belzer. We would offer to stipulate her testimony in, but we wanted to cover the nature of her testimony so that if the commission does have questions for her, we can make her available for any commission questions.
We'll let you know by the end of this witness.
We really appreciate that.
Thank
Thank you
you
for the consideration.
Thank you. Anything further before we continue with the witness testimony? Mr. Huber?
Madam Chair, I had one witness availability constraint I wanted to mention. One of our witnesses, Lane Collin, I do not expect we'll get to him today, but he is available only Wednesday morning, starting Wednesday at noon. He has to travel to actually, he's involved in another matter. He'll be tied up with the rest.
Do you not want to take him out of order today?
We could potentially after, I guess after witness, well, you're stipulating Smith in potentially.
Well, we're deciding on stipulating in. That's why I asked y'all to talk at lunch, to let me know if we need to take these witnesses out of order today.
We're okay calling him today. If the commissioner were agreeable to anticipate a question and the party
Or-
we're okay stipulating.
Or
his
first
testimony as
thing
well.
Wednesday morning?
Or first thing Wednesday morning. Yes,
Okay.
ma'am.
Well, y'all figure out the order you want. I'm trying to give y'all some leeway here. If y'all don't decide, I will.
No, we are okay calling him today, or first thing Wednesday morning.
Okay. Thank you, sir. Appreciate it. Anything further? Mr. Heath, would you please resume the stand? Mr. Heath, you're still under oath. Ms. Athens?
Thank you. So, Mr. Heath, before lunch, you were asked a couple of questions on certain provisions of the settlement regarding the means of sale and floating rate bonds by, I believe, Commissioner Thomas. Do you recall that line of questioning?
Yes, I do.
And in DEP's initial petition, the company asked for flexibility regarding those terms, the means of sale and floating rate bonds. Is that right?
Yes, we did.
And in direct testimony in response to DEP's petition, certain parties discussed those terms, I believe it was ORS, and also recommended that DEP be given flexibility with regards to means of sale and floating rate bonds.
That's correct as well.
And you also mentioned a couple of factors as to why DEP would need that flexibility with regards to means of sale and floating rate bonds. And one thing I did not hear you mention was the SEC rules and regulations. Is it possible that SEC rules and regulations could change to where Duke Energy Progress would need to maybe use a different type of means of sale, like a 144A?
It is. SEC rules are always subject to change.
And that's, again, why Duke Energy Progress asked to retain that flexibility with regards to the means of sale and floating rate bonds. Is that right?
That's one of the reasons, yes.
Mr.
And-
Heath, I'm sorry to interrupt, but I need you to, even though you're trying to look at her, I need you to talk into that microphone, please.
Okay.
Thank you.
Sorry.
And the settlement, although it retains the flexibility that Duke Energy Progress requested with regards to these terms, it actually adds some additional customer protections as well as transparency. Is that correct?
Yes, it does. If we choose to use a 144A issuance, or if we choose to use floating rate bonds, we would have to explain the rationale for pursuing those courses of action in the issuance advice letter.
Thank you. And I kind of want to touch on this flexibility. I know you mentioned that in response to some other questions as well. Do you believe the settlement agreement appropriately retains flexibility for the company?
Yes, I believe it does.
And would you agree with me that an overly prescriptive financing order that doesn't retain flexibility could raise issues for investors?
Yes, I believe it would.
And if investors had issues with the financing order and prescriptive terms included therein, could that affect pricing?
Yes, if investors knew that we were locked into a specific course of action and that we had to pursue a fixed course to issue these bonds, that could lead to could be detrimental to pricing.
And in turn, that would lower customer savings, correct?
It would lower customer savings. It would increase the storm recovery charges to customers.
Thank you. Do you have the settlement in front of you?
I do. I have it open right now.
If you could turn to page 12, I'd like to address some questions raised by Commissioner Thomas and Commissioner Caston regarding the QITP.
Okay.
And on page 12 at paragraph 2, the public interest as defined by South Carolina law, which the ORS is charged with a duty to represent, is listed. Is that right?
Yes, it is.
And I believe you heard Mr. Cooper read that provision out a couple moments ago, correct?
I did.
And that provision does not mention the utility's financial interest, does it?
It does not.
And would you agree with me, subject to check, that the ORS is actually stripped from considering the financial integrity of the utility and that it no longer has that duty?
I believe that's correct.
And are you aware that DCA is a consumer advocate?
Yes.
And it therefore represents consumers who take utility services for personal, family, or household purposes. Is that right?
That's my understanding.
And personal, family, household, that's more residential. Is that correct?
I would agree.
And now, does the storm recovery charge apply just to residential, or does it apply to all customers?
No, it applies to all current and future customers of Duke Energy Progress, regardless of their customer class, be it residential, commercial, industrial, lighting, whatever it happens to be.
And you were here a few moments ago when we were discussing DCA's role on the bond advisory team. Is that right?
Yes, I was.
And so as a result of this settlement, DCA and the ORS are both on the bond advisory team in one way or another. Is that right?
That is correct.
And you were also a participant on the bond advisory team in North Carolina. Is that correct?
Yes.
And I think you had some questions on whether there was a similar entity to DCA in North Carolina on the North Carolina bond advisory team. Do you recall that line of questioning?
I do recall that line of questioning.
And you said that there was not a similar party to DCA. Is that correct?
I said I didn't believe there was a separate entity similar to DCA.
Okay, thank you for clarifying. And there was the public staff on the North Carolina bond advisory team. Is that right?
That is correct.
And did the public staff in North Carolina provide a certification?
They did not provide a certification, no.
And so in South Carolina, is it fair to say that we have multiple parties on the bond advisory team looking out for customer interests, whether those are residential only or all customer classes as compared to North Carolina?
Yes.
And we also have a customer advocate, that being the ORS, actually providing a certification, unlike in North Carolina. Is that correct?
That is correct.
And I'd like to talk a little bit more about the certification. You had some questions regarding resolving disagreements on the bond advisory team. Do you recall those questions?
Yes, I do.
And Duke would be making final decisions on the bond advisory team. Is that right?
That's correct.
And that's because Duke is the party actually issuing the bonds or through its SPE. Is that right?
Correct. The SPE is the issuer and the sole owner or member of the SPE is Duke Energy Progress.
And Duke Energy Progress would be the utility or party in the transaction, actually subject to SEC regulations as well as the commission.
Correct. Correct.
And regarding the certification, would you say it's fair that the certification serves as a check on Duke Energy Progress's decision-making authority on the bond advisory team?
Absolutely, I would agree with that.
So if DCA offers up a recommendation to the company that will lower costs to customers, and Duke Energy does not take that recommendation, can the QITP withhold their certification?
Presumably they could, yes.
And would Duke also not be able to even provide a certification, because in that instance, the company could not certify that they provided the lowest storm recovery charges consistent with market conditions at that time?
Yes, if the company, if we had concerns about other parties providing their certification, it would also lead us to have concerns about providing our certification.
And so is it fair to say that the certification process is an incentive to the company to actually take advice from ORS and now also DCA with respect to any advice they provide that benefits customers?
Absolutely.
And would you say it's commonplace in utility securitizations for issuance advice letters to be provided?
Yes, I would. The most deals are going to have an issuance advice letter. I don't think all of them do, but the vast majority do.
And in North Carolina, did the issuance advice letter provided by the company offer additional explanations for decision making as we have outlined in the settlement agreement?
No, it did not.
And in North Carolina, did the North Carolina Utilities Commission have an opportunity to question the company about what was included in the issuance advice letter?
No, they did not. I don't believe they did.
So would you agree that the South Carolina Public Service Commission has an additional opportunity to review the issuance advice letter that the company submits and question the company as to all decisions it has made and described within that issuance advice letter, unlike the North Carolina Utilities Commission?
Yes, it does, and I believe that makes the structure that we're proposing here stronger than many jurisdictions, if not most jurisdictions.
And again, in addition to the issuance advice letter offering additional transparency to the commission, we also now have 2 representatives of customers as opposed to just 1.
That is correct.
So I'd like to also turn to page, let's see, 4 of the settlement.
Okay, I'm there.
And I'm looking at paragraph B2. So it states that the settlement agreement is comprehensive and non-severable. Is that right?
That is correct.
So this settlement agreement does address all issues raised by parties in this proceeding.
Yes, it does.
And this settlement also states that all parties will agree to provide a joint proposed financing order. Is that right?
That is correct.
And that joint proposed financing order would incorporate the terms of this settlement agreement, including specifically those that offer additional customer protections as well as additional transparency to the commission.
That is correct.
And looking back to this paragraph, it's left to the commission whether to accept this settlement agreement, in whole or in part. Is that right?
That is correct.
So the settlement agreement in no way divests the commission of any authority it has on whether to accept or disapprove this settlement agreement. Is that right?
That is right. Not in any way does this settlement limit the commission's authority in this case.
All right. Thank you, Mr. Heath. No further questions right now.
Thank you, Ms. Athens. Commissioners, anything further? Just on the limited stuff she asked. Do you have a question?
Yes.
Commissioner Caston.
I do want to make sure I understand on that page 12, I guess 2 South Carolina Code 58.4-10B, where it talks about preservation of continued investment and maintenance of utilities. Do you agree that that doesn't apply to Duke's finance interest? Are you saying that has nothing to do with the utility?
Public interest means the concerns of the using and consuming public with respect to public utility services, regardless of the class of customer, and preservation of continued investment in and maintenance of utility facilities as to provide reliable and high quality services. I believe that is talking about the customer's consideration of the customer's interest in the maintenance and preservation of systems and the cost that's going to be ultimately recovered from customers.
Okay. All right, thank you.
Anything further? Mr. Heath, thank you for your testimony today, and you may stand down.
Thank you. My pleasure to be here.
Mr. Cooper, we do want to hear from witness Smith. Do you want to go ahead and put her up out of order, subject to consent of the parties?
Hey, Chair Belzer, with your permission, we would like to call Kim Smith to the stand.
Thank you. Ms. Gretchen, you want to go ahead and...
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Cooper, go ahead.
Thank you. Ms. Smith, would you please state your name and business address for the record?
Ms. Smith, that microphone is not on. Thank you, ma'am.
Yes, Kimberly Smith, 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed in what capacity, Ms. Smith?
I employed as a rates and regulatory strategy manager, employed by Duke Energy Carolinas, testifying today on behalf of Duke Energy Progress.
And did you, on May 31st, 2023, cause to be pre-filed in this docket direct testimony consisting of 22 pages and 7 exhibits?
Yes, I did.
And did you, on July 11th, 2023, cause to be pre-filed in this docket supplemental direct testimony consisting of 6 pages and 2 supplement exhibits?
Yes.
And did you, on August 10th, 2023, cause to be pre-filed in this docket rebuttal testimony consisting of 11 pages?
Yes, I did.
And did you, on August 22nd, cause to be pre-filed in this docket revised rebuttal testimony consisting of 10 pages?
Yes.
Do you have any changes or corrections to your pre-filed direct, supplemental direct, or revised rebuttal testimony?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Chair Belzer, at this time, I'd move that Ms. Smith's pre-filed direct, supplemental direct, and revised rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Smith's pre-filed direct, her pre-filed supplemental direct, is that right? Yes, supplemental direct, and pre-filed revised rebuttal testimonies will be entered into the record as if given from the stand.
Thank you very much. And Ms. Smith, did you prepare a summary for purposes of this hearing?
Yes, I did.
Would you please deliver it at this time?
Exhibits?
What's that?
Exhibits?
I believe we
just put in the testimony, not the exhibits.
I'm sorry. I thought we had put in the exhibits as well. I think it was put on. Oh, I would, sorry. Chair Belzer, I'd ask that we please move Ms. Smith's exhibits into the record at this time. For her direct, for her direct, supplemental, and rebuttal exhibits be moved into the record at this time.
I don't think there were any rebuttal exhibits.
What's that?
I think we just have direct and supplemental
Yeah, that's correct.
exhibits.
Sorry.
Okay. Ms. Smith's pre-filed direct exhibits, which I think are exhibits 1 through 7,
Yes.
will be hearing exhibit number 4, marked for identification as hearing exhibit number 4 and received into the evidence of this case. Ms. Smith's supplemental direct exhibits 5 and 6, is that correct?
Yes.
Will be marked for identification as hearing exhibit number 5 and received into the evidence of this case. Thank you.
Thank you. Ms. Smith, at this time, could you please deliver your summary?
I can. Good afternoon, Chair Belzer and members of the Commission. The purpose of my testimony is to support the calculation of the revenue requirement for the proposed charge to customers necessary to pay the storm recovery costs and financing costs of the company. The storm recovery costs consist of the company's incremental operation and maintenance expenses, or O&M, deferred capital costs related to capital investments incurred during the storms, and carrying costs deferred or projected to be deferred as regulatory assets. My testimony is devoted to 1, identifying and estimating the revenue requirement necessary to recover the storm recovery costs that the company proposes to finance using storm recovery bonds and recover through a storm recovery charge. 2, providing a comparison between the net present value of the cost to customers that are estimated to result from the issuance of storm recovery bonds and the costs that would result from the application of the traditional recovery method or the quantifiable net benefits to customers. 3, describing the methodology for allocating the storm recovery charge among customer classes. And 4, addressing whether the company plans to establish a storm recovery reserve at this time. In my supplemental direct testimony, I support the statement that storm securitization is expected to result in approximately 24% customer savings compared to the traditional recovery model to recover these costs. I explained that by using the storm recovery charge model, the estimated net present value of the cost to customers is approximately $130 million based on market conditions that existed as of the date of the Phase 2 petition. By contrast, the estimated net present value under the traditional recovery model is approximately $171 million. The difference is approximately $41 million, or 24%. Barring significant changes in financing terms, embedded benchmark interest rates, or credit spreads of securitization bonds, the results presented in my testimony, including the revenue requirement for the proposed storm recovery charge, should closely approximate the final figures. In my rebuttal testimony, I explain why the company's proposal to establish a regulatory asset in the event that upfront financing costs were underestimated in the final issuance advice letter, which no party opposes, should include a return at the company's weighted average cost of capital and not just a debt return. I also explain that the company believes the return on ADIT, or accumulated deferred income taxes, should be subject to normal rate making, and that DEP plans to include the storm ADIT and rate base in its next general rate case proceeding. Finally, I have reviewed the terms of the comprehensive settlement and familiar with the terms and conditions contained therein. I support the settlement and respectfully ask the Commission to approve it. This concludes the summary of my pre-filed testimony.
Thank you, Ms. Smith. Chair Belzer, members of the commission, Ms. Smith is available for any questions.
Thank you, Mr. Cooper. Commissioners, questions for this witness? Commissioner Carolee Williams?
Thank you, Chair Belzer, and thank you for being here.
Oh, yes, thank you. Thank you for getting me in early today, too.
Of course. My questions stem from the decision to make this a 20-year amortization period. And I'd just like to get on the record more completely your ability to talk through the exhibits and why the 20 years makes sense. And there could be others that I should ask this of, but I didn't want to miss the opportunity. And I think it just comes from the question of, I know it's going to be cheaper over 20 years, but then you think about, you go back to 2014 and you think about it's a 30-year period that we're paying for it. So that's the backstory for my question, and I'd just like for you to add to the record in that regard.
So yes, thank you for that question. I think I would normally have deferred to Mr. Heath for this, but I will try to get on the record.
I asked you.
All the things you said were true. It definitely, the savings models show more savings if it's over 20 years. I think, at least from my point of view, I understand definitely what you're saying about the intergenerational impacts and the fact that some of these storms, well, as of next year during the bond issuance, the 14 storms will be 10 years old, and Matthew was right on the heels of those, so those will be 8 years old, so definitely older. But this is a smaller jurisdiction. There are less customers to allocate these charges to, and the company just believed it made sense. It was, that balance between the company's financial interest and the customers, and spreading that out over time so customers don't have that rate shock. Mr. Heath may be able to add further testimony if he comes back up.
I'll try to avoid that. We put him through a lot. And I'll admit, do you have an exhibit that kind of looks at 10-year versus 20-year?
10-year on the storm bonds?
Right.
I do not have that with me. I'm sorry.
Okay. But that was part of your analysis?
I don't know that my analysis ever covered that, because we're going to use 20 years all along. So we did look at the traditional model in a little different view, but the 10-year and the 20-year traditional model both end up with the same present value at the end of the day. So that kind of didn't matter in this case. But no, I did not do an analysis on 10 years for the storm bonds. We could provide that to you if you would like to see it.
Thank you for the offer.
Mm-hmm.
What witness would I ask of, if you know, how the bill is going to be labeled?
That would be witness Moore.
Thank you. I appreciate it.
Yes.
With all the settlement, it kind of all begins to run together. So
I understand. It's a lot to.
I hope you have a good celebration whatever you're getting ready to do.
Thank you.
Thank you. No further questions.
Commissioners, further questions for this witness?
One follow-up, if I may.
Commissioner Caston?
Relative to that 20 years, you said you didn't run, any analysis that's what Duke had decided to do from the beginning. Is that correct?
I think so. That's my understanding when I came into the process, that we were going to do a 20-year bond. There was never a discussion to do a 10-year bond, I don't believe.
Okay.
There may have been discussion amongst the Treasury team, but I was not a part of that. When I put the calculation together for the benefits calculation, it was always that we were going to use a 20-year model for the bonds.
Is there anyone coming up that would know the answer? I mean, not saying that 20 years is bad. I mean, just...
I don't know if Mr. Heath would have any. As I said, we could run those models for you as a late vault exhibit if you would like that.
I didn't ask that. No, ma'am.
Okay.
Thank you.
Commissioners, anything further? Any redirect?
And no, Commissioner, no redirect, and we'd ask that the witness be able to step down and be excused, please.
You're going to put me on the spot, aren't you? Ms. Smith, thank you for your testimony today. You may stand down and you may be excused.
You. Pleasure to be here. Thank you.
Thank you.
Chair Belzer, just would like to say to you and the commissioners, as well as the other parties, thank you very much for accommodating this request. We really appreciate it.
Well, we're all in this together, and since we kind of switched some days around, we have to work together. So I appreciate everybody being flexible. Thank you. Duke, your next witness. Mr. Cooper, Mr. Robinson, or are we going out of order?
Chair Belzer, just want to give ORS an opportunity if they wanted to modify the order.
I believe the plan was to do settlement witnesses, so I guess it'd be either Rothschild next, or we could call Mr. Collins since he's unavailable after Wednesday.
Tell
morning.
me which way you want to go. I'm fine.
If we want to go with Mr. Collins first, do you mind if I take a 5-minute break? I believe he's on WebEx, but I'd like to confirm
He's on WebEx. They're shaking their head.
Okay.
Do you want to try to do Mr. Rothschild and then Mr. Collins?
That's fine with ORS.
We're going to have to finish around 4 o'clock the other day.
That's fine with ORS.
Okay.
Mr. Collins available Wednesday morning. So.
All right, that's fine.
Thank you, Madam Chair.
So we're going Mr. Rothschild?
That's correct. The department calls Aaron Rothschild.
Okay, thank you. Mr. Hall, you can come to the podium or you can remain at your desk, whichever you prefer. Thank you. Good afternoon, Mr. Rothschild. This is Chair Belzer. Can you hear me?
Yes, I can. Good afternoon.
I'm going to ask you to state your name for me, and then I'm going to administer the oath to you. Would you state your name?
Aaron L. Rothschild.
Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Mr. Hall, your witness.
Thank you. Good afternoon, Mr. Rothschild. Could you please state your full name and business address for the record, please?
My name is Aaron L. Rothschild. My business address is 15 Lake Road in Ridgefield, Connecticut, 06877.
Thank you. And by whom are you employed and in what capacity?
Rothschild Financial Consulting, and I'm the president.
Okay. And how long has your company been in existence?
Since 1985.
And what types of services does your company provide?
Currently, we primarily provide financial testimony in the utility rate case proceedings. Additionally, we provide monthly financial information to interested parties throughout the country. And in the past, we've also provided consulting services to an electronic trading firm that focuses on bond and digital securities.
Thank you. And how long have you been preparing rate of return testimonies?
I've been involved in rate of return testimony since 2002, and I've That's included testifying as an expert witness in over 75 cost of capital proceedings. And this is the 10th time that I've filed testimony before the South Carolina Public Service Commission.
Thank you. And have you also prepared utility securitization testimonies in the past?
Yes, this is the 4th testimony I've filed regarding utility securitized bond proposals. And additionally, my firm has also been involved in numerous utility securitizations, including Atlantic City Electric and Jersey Central Power and Light.
And how has your experience helped you prepare securitization testimony?
Generally, from my finance experience and education and ongoing research, I've learned that marketing securities to investors is complicated and requires specialized knowledge and training. In preparing my 2020 California testimony, I reviewed all materials from all state commission proceedings that involved similar utility applications for orders authorizing the use of ratepayer-backed bonds, similar to recovery bonds from 1997. I learned that without the right oversight, it's impossible for regulators to determine if the issuance process is working, which is to save consumers as much money as possible. And additionally, my extensive experience testifying rate of return proceedings means that I understand the relative cost of capital for different securities, including utility securitized bonds.
Thank you. And did you prepare 20 pages of settlement testimony for this docket, which was filed on September 8th, 2023?
I did.
And did your testimony include 6 pages of appendices labeled Appendix A and Appendix B?
Yes.
Do you have any changes or corrections to your testimony?
I do not.
If I asked you the same questions today, would your answers be the same?
Yes.
Madam Chair, I would move to have the pre-filed settlement testimony of Mr. Rothschild entered into the record as if given orally from the stand.
Mr. Rothschild's pre-filed settlement testimony will be entered into the record as if given from the stand.
And Madam Chair, I'd ask to have appendices A and B from his settlement testimony entered as the next hearing exhibits.
And Mr. Rothschild's appendices A and B will be a composite exhibit marked for identification as hearing exhibit number 6 and received into the evidence of this case.
Thank you very much. Mr. Rothschild, will you please provide a summary of your settlement testimony for the Commission?
Yes, I'd be happy to. The purpose of my testimony is to support the settlement agreement in this case, which is a result of a good faith and collaborative effort by all the parties in order to achieve an equitable resolution of all the complex issues within this proceeding. I explain how the settlement meets the best practices I have seen implemented in other jurisdictions, provides consumer protections, and addresses the following legislative requirements. 1, provide quantifiable net benefits to consumers. 2, achieve the lowest storm recovery charge consistent with market conditions and the terms of the financing order. The primary components of the settlement, which I address in my testimony and which provide consumer protections and address the legislative requirements, are 1, oversight of the marketing, pricing, and registering of the bonds. 2, composition of the bond advisory team and the opportunity for DCA to attend meetings and provide input. 3, explanation of decision-making and opportunities for the Commission to seek additional information after the issuance advice letter is submitted. And leaving the door open for additional discussions if the members of the bond advisory team are not prepared to issue the necessary certifications that the transaction is consistent with legislative requirements. While I generally supported DEP's initial proposal, it lacked some of the oversight I have seen in other states. The settlement provides additional layers of transparency, accountability, and oversight to help ensure the statutory objectives are achieved. Therefore, I recommend the Commission approve the settlement as a fair and just compromise in this matter.
Thank you, Madam Chair. Mr. Rothschild is available for questioning from the commission.
Thank you, Mr. Hall. Commissioners, questions for Mr. Rothschild?
Madam Chair,
Commissioner Irvin.
thank you. Mr. Rothschild, good afternoon.
Good afternoon.
I want to do a little bit of background concerning your testimony. We heard Ms. Smith just testify a few minutes ago that Duke Energy Project customers will receive quantifiable net benefits with the securitized bonds. And so she went on to tell us how that might work. But my follow-up question is that in this instance, since the ratepayers or customers of Duke Energy Progress are going to be solely on the hook for the payments over presumably 20 years, should we not require Duke Energy Progress to justify their actions so that it would not result so that it would result in the lowest storm recovery charge possible? You understand my question?
I believe so. You're asking in the context of the miscalculations in terms of, okay. And if I understand correctly, should Duke be required to make calculations, for example, that might evaluate whether a 10-year maturity date could be better than 20?
Correct. That's my first question.
Okay. Yes, I think it can be important to make the calculations. Absolutely, that would be something that would be could be helpful.
Would you be in favor of having a late filed exhibit as a part of our record so that we can make that comparison? You think that would be wise, prudent?
I think that would be helpful. I could not see a problem with making that type of comparison.
All right. Another area of interest that I wanted to discuss with you is the inherent conflict of interest that underwriters have in this process. Could you talk to us about that briefly?
Sure. I don't think it's controversial that the underwriter's interests may necessarily not be completely aligned with consumers. I think Mr. Heath had discussed that earlier, and that's been consistent with my research over the last few years. It's important for oversight. I think that one piece is that underwriters may want to make the deal go as quickly as possible, or have other interests with helping investors. And I think it's important that there's oversight to watch. Yeah.
And what form would that appropriate oversight take? For example, if you were sitting as a commissioner on the Public Service Commission of South Carolina, what would you insist on as appropriate oversight to protect ratepayers?
I think the most important aspects of oversight would be to have access to the necessary information, to be for whoever's doing the oversight to be able to be actively involved in the process, have access to the necessary information, and also have the expertise to be able to make to evaluate.
And I want to talk about expertise because in the proposed settlement agreement, the Office of Regulatory Staff has been chosen by the company as the qualified independent expert. This is a rather complicated area of finance and law, kind of mixed together, is it not?
Yes.
Is a lawyer for a state agency that has not been involved in securitization cases, are they going to be adequately trained and familiar with the process so as to provide what we would call qualified expert testimony that is independent? I mean, that sounds like a big ask to me.
Madam Chair, this is
Excuse,
Chris.
just a moment. We have Mr. Huber.
This is Chris Huber, ORS. I hate to object, but respectfully, I object that Mr. Rothschild is not able to speak to the qualifications and expertise of ORS. I
What is
believe
that?
that was the question. I don't know what the feedback.
I don't know what is that feedback. Mr. Huber objects to the question of Mr. Rothschild being able to speak to the qualifications of ORS, and I would have to sustain that objection.
Yeah, let me rephrase the question then. Mr. Rothschild, you've been involved in a number of these proceedings around the country. I believe that you said this is your fourth securitization bond issuance. Is that correct?
That's correct.
Do you find that you learn something every time that you get involved in one of these cases, nuance or facts and circumstances that you either didn't anticipate or didn't know about?
Yes, absolutely.
Does it take a level of experience in this area to adequately represent the public interest in the sense that you know what questions to ask and what follow-up questions are necessary and what additional information is required before you can be, quote, qualified?
Yes, I would say that it's necessary to be an expert in this area. Yes.
And without the expertise that we're talking about, it puts ratepayers at a disadvantage, does it not?
If the necessary expertise is not there to do the evaluation, yes, it would put ratepayers at a disadvantage. Yes.
Those are all the questions I have. Thank you, Madam Chair.
Thank you, Commissioner Irvin. Commissioners, further questions for this witness? Commissioner Thomas?
Thank you. Good afternoon, Mr. Rothschild.
Good afternoon.
And speaking of storm securitization bonds, do you happen to be located in an area that is being impacted today?
Regarding Connecticut?
Yeah, I'm just asking, I've heard that there's a storm that's impacting the Northeast, I suppose it is. Just wondering if you're noticing anything.
Oh, I hope the current hurricane will miss us. Yes.
Okay, well, I hope so too.
and South Carolina. Yes.
Yes. So do you believe that these bonds should be classified as corporate bonds?
My understanding is yes. It's the most important piece is that investors are educated and they really understand just the how safe these bonds are. That's primarily, and I think that generally speaking, it's better if investors think of these as more in line with corporate bonds as opposed to other types of bonds.
So one of the other types of bonds that you think would be disadvantageous would be asset-backed bonds. Is that correct?
Yes, that can be problematic because, as I know, I think it was Mr. Heath was discussing it. They're different than many asset-backed securities, such as pools of credit cards or auto loans. So it's very important that these don't get confused with some of those traditional asset-backed securities.
And what do you see as the primary effect if these bonds are categorized as asset-backed securities?
It could lead to overcharging consumers. That if they're marketed as asset-backed securities, the yield could be higher than they would need to be, and they also might not be at the ideal maturity date, which I've seen before. Like many asset-backed security investors are looking for maturity dates that are shorter than corporate bonds, and that we'll see more of the results of the analysis of evaluating the 20-year term. But generally speaking, when it's a shorter term, it's a less of a benefit to consumers. So just in summary, two potential problems. One is that could lead to a higher yield, and it also could lead to potentially marketing to a shorter maturity date, which may lead to lower benefits to consumers.
All right. And so are there specific steps that an issuer can take in the structuring and drafting the transaction documents to decrease the likelihood that the market will view these bonds as asset-backed securities?
Yeah, there are a number of steps. One would be how it's registered with the Securities Exchange Commission and what ticker they may receive. So they can be helpful if they are registered as corporate bonds as opposed to asset-backed securities. I'm not sure. Can you repeat your question?
Yeah, I was really referring to the structuring and the drafting of the documents to help keep them from being viewed as asset-backed securities.
Yeah, so that was the first piece in terms of how they're registered, and then later on in terms of how they are marketed, the types of investors that are called called in terms of potentially to buy these securities, and also in certain cases how they're classified in terms of as an index that may or may not be within any authority of the bond team. But one of the real critical pieces is how they are registered and how they are marketed to investors and communicated in terms of their basically why they're so much lower risk than other asset-backed securities.
Okay. So then the marketing and the communication around that is very important, and I think you gave some little bit of information there as to some points that should be covered. Did you have any other points?
I think those are. Those are the main ones that come to mind. I'm sure there could be some others.
Okay. And do you think there are any specific conditions that the commission should impose on the issuance that would decrease the likelihood that these would be viewed as asset-backed securities?
One condition would be how they're registered. Another condition, again, it's not clear to me how much, whether it's be possible with having a condition with being put on an index that would be a corporate index as opposed to an asset-backed index, or do whatever could be done within the authority of the commission to ensure that was achieved.
Okay. I appreciate that input. Thank you.
Commissioners, further questions? Commissioner Carolee Williams.
Thank you, Chair Belzer. Good to see you, Mr. Rothschild.
That's good to see you.
Did you hear the conversation earlier between the attorneys about the bond advisory team composition?
Yes, I did.
And is that, to the extent that you know, is that your understanding as well as to how the composition was defined with DCA as a invited, meaningful participant?
Yes, that was my understanding.
And then switching gears, in your experience, Are you experienced with qualified independent third party certifiers?
Do I have experience certifying?
No, no. Have you participated in securitization processes where there is a qualified third party? Have you testified in a case? Have you, delved into understanding a securitization case where there is a qualified independent third party?
Yes, as I had mentioned in my testimony summary, I had reviewed, as part of preparing my testimony for the Southern California Edison application to issue securitized bonds. I reviewed all of the issuances that I could see, and also I had recommended in California, which was consistent with the legislative requirements for there to be a bond advisory team. So in my research, when there was an independent qualified certifier, as similar to being proposed here, that it was in the best interest of consumers.
And are you aware of any circumstance like the one that is proposed for us in the settlement where a state entity is offering to serve in that capacity?
I'm not aware of that, no.
Thank you, Mr. Rothschild. No further questions.
Thank you.
Commissioners, further questions?
Madam Chair.
Vice Chair Powers?
Thank you, Madam Chair. Mr. Rothschild, good afternoon. Following up on what Commissioner Thomas was asking you about marketing and stuff, and remember in your testimony you talked about this. Some underwriters have lawsuits. Some are more aggressive at pricing. Just how do you pick these underwriters or court these underwriters or get them involved when you talk about marketing? How does that process work?
What's the process of a corporation like Duke selecting underwriters? How does that process work?
Yeah, I'm just curious about how do you get the right ones?
From my research in this area and my work testifying, I think the most important piece is to make sure that there is a necessary oversight. I think that the underwriters that I've seen are experts in their field, and they're certainly required in order to issue these bonds. So the important piece is to make sure that there is the necessary oversight so that they can really do their job, but make sure it's aligned with consumers. I know that in many cases there can be multiple underwriters. From my knowledge, though, I think the most important thing is to make sure that there is a necessary oversight, that you have someone who's independent, someone who has the expertise, and someone who can be involved in the process and really make a recommendation. So in terms of choosing the specific underwriter, what I say is most important is making sure that there's a necessary oversight.
And how do you make the process competitive with it?
Competitive in terms of the issuing of the bonds, or competitive in terms of getting the best underwriter?
Getting the best underwriters to the table.
I think issuing RFPs can be certainly a good way to be to compare different offers. I think that certainly is one way a powerful way to make sure the process is competitive.
Okay, thank you, Madam Chair.
Thank you, Vice Chair. Commissioners, Commissioner Caston.
Thank you, Madam Chair, and good afternoon, Mr. Rothschild.
Good afternoon.
What does consistent with market conditions mean to you?
What it would mean to me in simple terms would be if they're being issued today, or in the coming months. Unfortunately, the interest rate is probably going to be quite a bit higher than if they were issued a year or two ago. That's no fault of anyone's. It's just the markets have changed. So consistent with current market conditions would be that if you look out in the market, other bonds of similar risk are being issued at a certain interest rate, that these bonds should be similar, and that would be consistent with current market conditions.
Okay, so thinking in terms of the certifier, what does that mean to the certifier? In other words, who determines what the market conditions are?
A certifier would certainly be important to evaluate current market conditions and make sure that the pricing, if they're about to issue the bonds, that is consistent with current market conditions. And that isn't necessarily easy to determine. It's not necessarily that you can look up the interest rate and compare. You would have to determine what bonds are comparable and maybe do some type of interpolation to find an interest rate that would be comparable with the terms of the bonds that are being issued. So it'd be critical to not only look at published market data, but be able to do the necessary analysis to be able to really do a benchmark comparison. That would be a critical aspect.
Okay.
And another piece, just to add to that, might be to be able to just be monitoring and see how the marketing is going, just to make sure that at the table you've really marketed to as broad a set of investors as possible, and you have just as many investors that are fully informed at the table to be making bids.
Do you believe this agreement will achieve lowest cost storm recovery charges?
I do. I believe this is. I support the settlement agreement. There's a lot of work that was put into this by all involved, and I think this is very, very promising because of the additional oversights that were put into place here. Having DCA to be able to be actively involved and to be informed, so I think it's very, very helpful. I just would like to emphasize that it really comes down to implementation, and no matter what you have on paper in an agreement is only as good as how it's actually going to be implemented. Will people step up to the plate and really look at the data and really monitor? So it's all going to come down to the implementation.
Well, won't that primarily be the BAT?
Yes.
So with that in mind, do you believe the DCA will have the same consideration or clout, if you want to call it, as ORS or DEP?
That's been that's my understanding from everything I've heard, that DCA would have as much opportunity for input, and I think that's critical.
Okay. Thank you, Mr. Rothschild. I appreciate it a lot.
Thank you.
Commissioners, anything further?
Madam Chair,
Commissioner Irvin?
just to follow up, Mr. Rothschild, is it fair to say that ensuring that the bond is appropriately structured correctly at the outset is critical to successful bond issuance?
Yes, I believe so.
All right. And once the bonds are sold, the South Carolina Public Service Commission gives up all further review of the storm recovery bonds, including the charges that were made, and the commission cannot alter the Duke Energy Progress rates for any reason. Isn't that true?
That's correct.
So that makes it even more imperative to get it right in the planning process. Would you agree with that?
That's right. We don't get a second chance.
I'm just wondering whether you would be willing to serve as a certified independent third party expert in this case. Did anyone consider using you, since your background, qualifications, and experience are obviously impressive?
I have not, nobody has asked me to serve in that role.
If you were asked, is there any reason why you could not serve in that role?
I would want to understand the more context in terms of what I would be asked to do and what resources I would have. I would consider it, but I would want to understand more about the role.
Okay. And how would you get that information so that you, if the job was offered to you, how would you go about getting the information you need to make a decision?
Chair Belzler.
I'd like to make an objection that this is outside the scope of the settlement and the settlement testimony that Mr. Rothschild provided, where he supported ORS as the QITP.
I'd like to be heard on that objection, Madam Chair.
Commissioner, you're asking questions, but I mean, yeah, this is.
Let me just ask you this.
I'm going to sustain the objection, Mr. Commissioner, but
I'll go on and ask another question. You familiar with the South Carolina statutory scheme that relates to bond securitization in South Carolina?
Yes, that's the primary pieces, as I stated in my testimony summary.
Right.
Yes.
And so it gives the commission the authority to select or choose the qualified independent third-party expert, does it not?
Yes, that's what I recall.
Thank you. No further questions.
Commissioner, did you want a late filed exhibit? I hate to ask this question, but you mentioned it, and it's not in the record yet.
Yes, I think it would be helpful to have it just for the record. And so it was offered earlier, and so Ms. Smith, I don't know if she's still with us, but somebody from the company could get that to us in a timely manner. That would be great.
And tell me specifically, what is it that you're requesting?
It's the 10-year versus the 20-year term. Commissioner Carolee Williams asked about that, and just to have a complete picture, it might be helpful to have that on the record. So if that's available from the company,
we'll find out if it's available. Thank you, Commissioner. Mr. Robinson, is such a 10-year versus 20-year analysis or model, or however it was described, is that available?
Yes, Chair Belzer, we'll be able to provide that late filed exhibit.
And can you give me a time frame on that? These open-ended late filed exhibits can drag on for a while, so.
Understood, Chair Belzer. We'll do it as soon as possible. We may even be able to, recognizing the timing here today, we may be able to speak to it on Wednesday, but we'll do our best to try to get it to you as quickly as possible.
We will reserve hearing exhibit number 7 for this late filed exhibit. Any further questions of this witness? Hearing none. Ms. Athens, is this? No, we're on Mr. Hall. Mr. Hall, any redirect?
Thank you. Mr. Rothschild, do you have the settlement agreement handy?
I do.
Okay. Can I ask you to turn to page 10, please? And I'll ask you my question at first, but I'm going to ask you about paragraph 24. So Commissioner Thomas asked you about some of your concerns with asset-backed securities and how they're structured and how these bonds will be structured and drafted, and you commented on marketing. Paragraph 24 states that Duke will work with the parties and members of the bond advisory team to develop appropriate and necessary disclosures in the registration statement and other marketing materials, including but not limited to highlighting the credit features of the storm recovery bonds, such as the true-up, non-bypassable nature of the charges, the state pledge, bankruptcy and reorganization protections, and non-appealable financing order. Is that correct?
That's right.
And were those provisions put there to address your concerns about asset-backed securities?
Yes, these provisions were serve that purpose. Absolutely.
And these are that list that I just read. Those are some of the things, I guess, the benefits that these bonds will have that typical asset-backed securities will not have. Is that right?
That's correct.
Okay. That's all the questions I have. Thank you.
Thank you, Mr. Hall. Bear with me just a moment. Ms. Athens?
Yes, Chair Belzer, thank you. Given the questions that witness Rothschild was asked regarding the QITP, Duke Energy Progress just wanted to note for the record that we only stipulated to his settlement testimony, and we did not stipulate to his qualifications or his qualifications to serve as QITP, and just wanted to make that clear for purposes of the record.
Thank you.
Madam Chair,
Commissioner Irvin?
since the commission is authorized by law to choose and designate the qualified independent expert, I would ask that we accept Mr. Rothschild's qualifications listed in his earlier testimony as a late filed exhibit and made part of the record.
His Appendix A and B attached to his stipulated testimony is already in the record. And I think we better look at the language of the statute, because the statute says that the commission may designate a third party, an qualified independent third party. The word choose is not used there. And designation can occur in any number of ways. I just put that out there, so. But his qualifications, I believe, are contained in his, let me look back at his Mr. Rothschild, is the Appendix A and B, your qualifications, are those the same that was attached to either your direct or your rebuttal?
I believe so. Let me check.
So his qualifications are in the record, Commissioner, as hearing exhibit number 6.
Thank you.
Thank you. Anything further of this witness? Mr. Rothschild, thank you for your testimony today, and appreciate you being with us virtually, and you may stand down.
Thank you.
Thank you, sir. Now, who do we go to? Mr. Huber?
Madam Chair, if it's okay with the commission and the parties, I'd propose to call Mr. Collin next, since he has that availability limitation on Wednesday. That way we go ahead and get his testimony in the record today.
Any objection to calling ORS witness Collin? Okay, Mr. Huber, go forward.
Thank you, Madam Chair. Sorry, ORS calls Lane Collin, and Mr. Collin is appearing virtually.
Mr. Collin, would you turn your camera on, please?
Yes, ma'am.
Good afternoon. This is
Good
Chair Belzer. I don't think you can see me yet, so I'm going to ask you to state your name for me and then raise your right hand so I can give you the oath.
Yes, my name is Lane Collin.
Mr. Collin, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Mr. Huber, you're recognized.
Thank you, Madam Chair. Mr. Collin, will you please state your full name for the record?
My name is Lane Collin.
And by whom are you employed and in what capacity?
I'm employed by J. Kennedy and Associates Incorporated as a vice president and a consultant.
And are you the same Lane Collin who prepared or caused to prepare 20 pages of pre-filed direct testimony in this docket that was filed on this docket on July 26, 2023?
Yes, I'm sorry.
Do you have any corrections or edits to your pre-filed direct testimony?
No.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes.
Madam Chair, ORS asked that Mr. Collins' 15 pages of pre-filed direct testimony be entered into the record as if given orally from the stand.
I have more than 15 pages of direct.
Sorry, 20 pages of
Thank
direct.
you.
Apologies.
Mr. Collins' pre-filed direct testimony will be entered into the record as if given from the stand.
Mr. Collins, did you also cause to be filed with your direct testimony 6 exhibits marked as Exhibit LK1 through LK6?
Yes.
Do you have any changes, edits, or corrections to your exhibits?
No.
Madam Chair, ORS asked that Mr. Collins' exhibits marked as LK1 through LK6 be admitted into the record as the next composite hearing exhibit.
Mr. Collins' pre-filed direct testimony showing labels of LK1 through LK6 will be a composite exhibit marked for identification as hearing exhibit number 6 and received into the evidence of this case.
Thank you, Madam Chair. Mr. Collins, did you also prepare or cause to prepare 8 pages of rebuttal testimony on August that was pre-filed in this case on August 22nd, 2023?
Yes.
Do you have any corrections or edits to your pre-filed rebuttal testimony?
No.
If I were to ask you the same questions today as those posed in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Madam Chair, ORS asked that Mr. Collins' 8 pages of pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Collins' pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Mr. Collins, have you prepared a summary of your direct testimony?
Yes.
Will you please present your, summary of your direct and rebuttal testimony, correct, Mr. Collins?
That's both testimonies, that's correct.
Will you please present your summary to the commission?
Yes, I filed direct and rebuttal testimony in which I addressed quantifiable net benefits from the securitization financing compared to the costs that would have resulted from the application of the traditional method of financing, ensuring that customers receive the entirety of those benefits and the establishment of and periodic revisions to the storm recovery charges. I recommend the Commission find that the proposed issuance of recovery bonds and the imposition and collection of a storm recovery charge will provide quantifiable net benefits to customers on a present value basis, but subject to 2 conditions necessary to ensure that there are actual benefits to customers and that the entirety of the savings are provided to customers. To achieve the first condition, I recommend the adoption of a cap on the cost of the securitization financing to ensure that the actual financing remains cost effective and that there will be actual quantifiable net benefits if interest rates increase prior to the actual securitization financing. In the settlement agreement, the company agreed to a cap on the cost of the securitization financing. To achieve the second condition, I recommend that the Commission direct the company to defer carrying costs on the storm cost accumulated deferred income taxes, which are referred to as ADIT, at the pre-tax weighted average cost of capital, which is referred to as WACC, to a regulatory liability established for this purpose from the date of the securitization financing when it closes until the date when the storm cost ADIT is finally reflected in base rates in a future general rate case proceeding. The company proposed to retain these savings until base rates are reset in a future rate case proceeding. In the settlement agreement, the company agreed to defer the carrying costs on the storm cost ADIT at the pre-tax weighted average cost of capital, consistent with my recommendation. I also recommend that the company's proposed financing order and its proposed storm recovery charge tariff provide a detailed description of the data, the source of the data, and the actual calculations that will be used to reset the storm recovery charge rates every 6 months or more frequently through interim true-ups if necessary. In the settlement agreement, the company agreed to use the more detailed language that I recommend.
Thank you, Mr. Collin. And Mr. Collin, have you had an opportunity to review the settlement agreement into which parties to this proceeding entered?
Yes.
Do you support the settlement agreement as a just and reasonable resolution of this proceeding?
Yes, all of my recommendations, both in direct and rebuttal testimony, were adopted in the settlement agreement.
Thank you, Mr. Collin. Does this conclude your summary?
It does, yes.
Madam Chair, Mr. Collins now available for questions from the commission.
Thank you, Mr. Huber. Questions for this witness, commissioners? Hearing none. Mr. Collin, thank you for your testimony today. You may stand down.
Well, thank you very much.
And Madam Chair, may I ask that Mr. Collin be excused? I know it's at my own peril.
Subject to your peril.
Thank you, Madam Chair.
Unless he's going out of the country.
And one thing I wanted to take up, and we can do this now or at the end, I wanted to make sure I moved Michael Seaman Wynn's pre-filed direct testimony to the record.
Why don't we do that at the end? If you
Do
don't
that at the
mind?
end? Okay,
Yeah.
thank you, Madam Chair.
Okay. Are we going with Mr. Roden next as a settlement witness?
Yes, Madam Chair. We can certainly call Mr. Roden. I don't know how many questions will be for him, but we're certainly glad to go ahead and get him on the stand. And
Well, I'm not trying to tell you. I just thought y'all were doing the settlement witnesses and these out of order ones first. So
that was the plan, Madam Chair,
Okay.
yes.
Mr. Roden? Go ahead.
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Roden. Would you please state your name for the record?
My name is Mark A. Roden.
And by whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff.
Are you the same Mark A. Roden who prepared or caused to be prepared 15 pages of pre-filed direct testimony in this docket on July 26, 2023?
I am.
Do you have any corrections or edit to your pre-filed direct testimony?
I do not.
And if I were to ask you the same questions as those posed in your pre-filed direct testimony today, would your answers be the same?
Yes, it would.
Madam Chair, ORS asks that Mr. Roden's 15 pages of pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Roden's pre-filed direct testimony will be entered into the record as if given from the stand.
And Mr. Roden, did you also prepare or cause to be prepared 7 pages of rebuttal testimony in this docket on August 22nd, 2023?
Yes.
And do you have any corrections or edits to your pre-filed rebuttal testimony?
I do not.
And if I were to ask you the same questions as those posed in your pre-filed rebuttal testimony today, would your answers be the same?
Yes, it would.
Madam Chair, ORS requests that Mr. Roden's 7 pages of pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Roden's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
And Mr. Roden, did you also prepare or cause to be prepared one exhibit marked rebuttal exhibit MAR1 that accompanied your rebuttal testimony?
Yes.
And do you have any changes or corrections to your exhibit?
No, I do not.
Madam Chair, ORS asks that Mr. Roden's pre-file rebuttal exhibit marked as MAR 1 filed with his rebuttal testimony be marked and entered into the record as the next hearing exhibit.
Court reporter is correcting me that maybe on the last exhibit I said 6, but that should have been hearing exhibit 8 for Mr. Collins' exhibit, so I'm correcting that to the extent I misstated. And we are to Mr. Roden's surrebuttal exhibit MAR 1. That will be marked for identification as hearing exhibit number 9 and received into the evidence of this case.
Thank you, Madam Chair. And Mr. Roden, did you also prepare a cause to be prepared 3 pages of settlement testimony in this docket on September 8th, 2023?
Yes, I did.
Do you have any changes or corrections to your pre-filed settlement testimony?
No, I do not.
If I were to ask you the same questions as those posed in your pre-filed settlement testimony, would your answers be the same?
Yes.
Madam Chair, ORS asks that Mr. Roden's 3 pages of pre-filed settlement testimony be entered into the record as if given orally from the stand.
Mr. Roden's pre-filed settlement testimony will be received into the record as if given from the stand.
And Mr. Roden, did you prepare a summary that includes your direct, surrebuttal, and settlement testimonies?
Yes, I did.
Would you please present that at this time?
Sure. Good afternoon. First, I would lead off with the ORS mission, which is to represent the public interest as defined by the South Carolina General Assembly in that appropriate statute. We represent the concerns of the using and consuming public with respect to public utility services, regardless of the class of customer, and preservation of continued investment in and maintenance of utility facilities so as to provide reliable and high-quality utility services. In regard to my direct testimony, I discussed and/or made recommendations regarding the following. ORS does not object to the company's request to update the estimated deferred carrying cost component of the $170.6 million as approved in phase 1 of this proceeding. ORS does not object to the company's request to establish a regulatory asset which defers upfront financing costs in excess of final estimates included in the issuance advice letter. ORS is not opposed to the company receiving carrying costs on the regulatory asset, but in my direct testimony, ORS disagreed that the carrying cost should be at the company's weighted average cost of capital. Rather, the carrying costs were recommended in my direct at cost of debt. ORS recommended the utility assessment fees, which is a component of ongoing financing costs, should not be calculated on storm recovery charges. And finally, in my direct, ORS recommended the company seek guidance from the South Carolina Department of Revenue as to whether license fees and sales taxes should be assessed on storm recovery charges. With regard to my surrebuttal testimony, I affirm ORS's position proposed in my direct testimony regarding carrying costs on any commission approved regulatory asset which defers upfront financing costs in excess of those final estimates, and it be at a cost of debt as approved in the commission order in the previous docket. I also, in my surrebuttal, responded to company witness Sparrow's rebuttal testimony related to utility assessment fee, the license tax, the sales tax, and the time period for the semi-annual and other necessary true-ups. And finally, in my settlement testimony, I support the comprehensive settlement agreement that was entered into between the parties, the company, the DCA, Nucor Steel, South Carolina, and ORS in this proceeding. The settlement agreement is the result of earnest good faith and complex negotiations between parties with diverse interests. In the spirit of collaboration, each of the parties made compromises from their original positions to achieve a balanced resolution of certain issues in this proceeding. Further, ORS believes that the settlement agreement is in the public interest of South Carolina and respectfully requests that the Commission approve the settlement agreement as presented. This concludes my testimony.
Thank you, Mr. Roden. Madam Chair, Mr. Roden is available for questions from the Commission.
Thank you, Ms. Rainey. Commissioners, questions for this witness? Vice Chair Powers.
Thank you. Thank you, Mr. Roden, for being here. You mentioned the public interest as being ORS's mission, ORS's job. And yet at the same time, ORS serving as the QITP. Do you see no problem with that?
As I stated in my summary, I support the agreement, so that is correct. I do not have a problem with that. As stated previously by the attorneys in this room, and I appreciate that, the ORS mission seems to line up, in my view, with the objectives or the requirements of the statute.
Okay. Well, the public interest would include ratepayers, would it not?
Yes, indeed.
In fact, public interest would include the interest of the utility, would it not?
You know, the ORS mission, as defined, is for the customers. And if I could refer back to it, it does not mention the utility in our mission statement.
Well, and the reason I say that is the utility's interest is certainly going to be different than the interest of ratepayers.
You know, now, to the extent that it involves or impacts the utility, you know, part of our mission is to preserve the continued investment in and maintenance of facilities so as to provide reliable and high-quality service. In that regard, it's focused on the customer, but the utility has to make the continued investment to serve the customer.
Would part of ORS's responsibilities as to the public interest, wouldn't that give them kind of the same obligation that the Department of Consumer Affairs has?
I don't have a good understanding of the Consumer Affairs mission, to be honest with you. I've been at this 4 years. I'm just now, you know, grasping the ORS mission. So.
Okay. All right. But you think under the Act 227, the Securitization Act, that it's proper for ORS to serve as QTIP?
You know, I do, but I don't do this alone. This entire process, through all the parties involved, the ORS, the company, the DCA, the consultants, I believe, in the Act, and the process, I believe, supports that.
And you've had input into the process and into these decision-making?
You know, the input I've had specifically is related to the summary of my testimony. Some of the issues I have not, you know, have not been involved in.
Okay. Well, thank you very much. That's all I have, Madam Chair.
Thank you, Vice Chair. Commissioner Caston.
Thank you, Madam Chair. Good afternoon, Mr. Roden. And I guess I'm going to ask the same question, understanding that you've only been there 4 years. I've been here less than that. So I guess I'm trying to understand it too. Relative to Section 58.410B, when I read that and hear you guys read it, that last part in particular that you read a couple of times, preservation of continued investment and maintenance of utility facilities so as to provide reliable and high quality service. Does that, in your mind, not apply to the utilities financial interest at all?
Well, obviously, to the extent that, you know, in any rate case or any proceeding, you know, any order out of this results in a reimbursement, you know, to the utility, absolutely. But as far as, you know, beyond that, our objective is to represent the using and consuming public, you know, with our mission involved as read. Now, that's a broad definition, but that's how I would describe it.
Well, what might be helpful for me is if y'all could huddle together and kind of make sure we're all in one accord, or at least make sure I understand it. Because I've kind of been under the understanding that, yes, they're using and consuming public, but that doesn't mean at the expense of the utility no matter what. So,
yes, sir.
I just need some clarification on that going forward.
Madam Chair.
Ms. Rainey?
Mr. Roden is not an attorney, and he works for the Office of Regulatory Staff, not the DCA. I think that calls for a legal conclusion of what the.
I'm not going to ask Mr. Roden to answer that, but I think that the question might be for the attorneys to get their heads together and provide some clarification. Is that correct?
Thank you, Madam Chair. And I wasn't asking about what he thought the role of DCA was.
So I would ask y'all to huddle up today and just have something that you can talk to us about on Wednesday, if you would. But I don't think the commissioner's asking Mr. Roden to answer that question. Am I correct?
Thank you, Madam Chair. And look, I'm not trying to be mean and hateful about that at all. I mean it. I'm really trying to understand this because I want to. If you ask me what my mission is, I don't, but I could tell you. I want you guys to be in one accord. I want ORS to be in one accord. I want us all to understand what you do, what it means.
Fair enough.
Okay. And you've probably kind of been asked this, but I'm asking anyway. Do you believe that this agreement will achieve the lowest cost storm recovery charges?
Yes, I do.
And I will ask this about DCA. Do you believe DCA will have the same consideration, clout, whatever, as DEP and ORS?
Yeah, I really wasn't involved in that particular discussion when the parties came together on that issue. I have no reason to believe otherwise, though.
All right, understand. Let's see. And was not the cost of debt used for the prudency phase of this when, rather than weighted cost of capital, weighted average cost of capital?
Yes, it was.
So any particular reason? I mean, why did you feel like weighted cost of capital versus cost of debt was okay now?
Yes. Let me say this first. Witness Collin, in great detail, provided analysis and answers to that. But the greatest one in which he gave was the fact that in the company's calculation of net quantifiable benefits, that the company used the weighted average cost of capital. And part of that is the ADIT at WAC, part of that quantification. And Witness Collins' recommendation, which I of course support, is simply for the company to follow through on that calculation and set up a deferred liability, which is the only way that benefit can be realized for that ADIT.
Okay. Thank you. And I guess relative to that floating rate, potential floating rate. Do you have any concern relative to it could float up?
I have no concerns, but that's primary because of my lack of knowledge on it, sir.
Good answer, I guess.
Yeah.
Thank you, sir. No
Yeah.
more questions, Madam Chair.
Thank you, Commissioner Caston. Commissioners, questions for this witness?
Madam Chair,
Commissioner Irvin?
thank you. Good afternoon, sir. How are you today?
Good, thank you.
Great. Have you ever participated yourself in a storm securitization bond issuance process?
No, I have not. This is my first experience.
Do you know anyone that works with you at the Office of Regulatory Staff that's ever been involved in a securitization bond process like the one we're discussing today?
You know, this is the first time for the statute in South Carolina, so I don't know, about their individual experiences, but subject to check, I would say we as an agency have not dealt with a securitization case before.
For that reason, don't you think it might be helpful to have a qualified, independent expert involved to guide the parties through this process and report back to the commission? And I'm talking about someone that's been through this process several times before and understands the pitfalls and the potential issues that will arise in the course of the various decisions that have to be made.
Yes, sir. I support the stipulation and the agreement between the parties. Now, the ORS, of course, the attorneys gave explanation to how that came about earlier, and I'll reiterate, I appreciate that. I can only add to your question that the ORS has been involved in this rate case in phase 1 and phase 2 extensively. The ORS, again, as mentioned before, represents the public interest, which we believe aligns with the statute. And
I appreciate that explanation, I really do. And don't get me wrong, I think that the Office of Regulatory Staff has done an exceptionally good job of representing the public interest during the time, the 5+ years that I've been on the commission. But my point is, since they've never been involved in a securitization bond issuance, don't you think it's just common sense that it would be helpful to have someone who has the requisite qualifications, background, and experience to be designated by the commission to guide the process and ensure that the least cost are passed on to ratepayers?
Madam Chair.
Ms. Rainey?
Madam Chair, I object to this question. It's been asked and answered. Mr. Roden has testified that he supports the settlement agreement, and he believes that ORS can serve as a qualified independent third party.
He has, but the question was a little bit different, so I'm going to allow, if the witness can answer that, if he's able to.
Do you want me to repeat the question?
Thank you so much.
All right. I know you're not an attorney, but don't you think it would be helpful for the entire process for all of us to have confidence in the process, to have someone who is exceptionally qualified and has the qualifications to see the possible pitfalls and issues that are bound to come up in this process that we're discussing? This securitization bond issuance is a very complicated area. You agree with that?
I certainly agree with your logic.
Commissioner Urban, would you mind if I pose a couple of questions that might help this along?
Not at all. Go ahead, Madam Chair.
Thank you, Commissioner. Good afternoon, Mr. Roden.
Good afternoon.
I don't want you to divulge any kind of secrets or get into, I don't know if you were involved with any of the settlement discussions or not. I don't want you to divulge any of that. But you're in the financial area at ORS, is that correct?
Correct.
And are you familiar with the statute that allows for ORS to hire outside consultants and experts to help in its cases?
Yes, I'm aware that we do that. The statute itself, I've not read, so.
All right. And do you know if ORS is planning to continue to use an outside expert? Should it be designated as the QITP?
Certainly, at any point in time in an engagement, the ORS uses great discretion in using consultants when needed.
Okay. I think y'all got a consultant in this case, Mr. Traska, as well as Mr. Collin, but Mr. Traska seems to have had some experience in this area, has he not?
That is correct.
Area I'm talking about securitization.
That is correct. We have a consultant on this case.
Do you know, if you can answer this at this point, do you know if the settlement agreement is approved and if the ORS is designated as the QITP, has ORS made a decision whether they would continue utilizing Mr. Traska in this manner?
No decision like that has been made thus far. I am aware of that. I had limited involvement in this settlement, but I am aware that we've not gone that far.
But ORS typically engages outside consultants for work where there are no in-house employees that have expertise in a subject matter area. Is that correct?
Certainly, and I'll use phase one as a great example of that issue, using J. Kennedy and Associates, this being the very first securitization case in the state of South Carolina. That was a massive, huge lift. Auditing to the level that we did, and we did not have that capacity nor that expertise. May have done it, but not as efficiently because they had experience in the past. So absolutely yes to your question, and this case is a great example of it.
Well, and this is a continuation of this first securitization. So to the extent that ORS may need to hire an outside consultant to participate in the next phase, is it feasible that ORS would do so? I know you can't bind I'm not asking you to bind the agency. I'm just asking if that's feasible.
Subject to my attorneys and the leadership at ORS, absolutely feasible.
Okay. And just as are you familiar with the Securitization Act? I'm not asking for a legal opinion here, but just some points maybe. I mean, have you read through it?
Yes.
And you're aware that under the Securitization Act, that the commission in hiring consultants, that those fees would be charged as cost of this under the securitization that would be folded in to the financing cost.
Yes, I am aware of that.
I might be using the wrong term, but anyway, they'd be added to the pot that's going to be collected.
The upfront financing costs.
And under ORS's statute for hiring outside consultants and experts, would you agree, subject to check, that the cost or the fees associated with hiring those consultants and experts, ORS could either choose to pay them if they have it in their budget, or they could charge it to the case that is ongoing, and the utility would fold that into a rate case or presumably a securitization case?
Absolutely. Under the statute, we could charge it to the case, and I've refused to answer that first part.
Okay. I don't blame you there. But to the extent that that ORS had to hire an expert, those costs could be, at ORS's discretion, put into the cost of the securitization.
Subject to check, sure, yes.
Okay. All right. Thank you, sir. I appreciate that. Thank you, Commissioner Irvin.
one follow-up question, Madam Chair.
Yes, sir, Commissioner Irvin.
Thank you. And if there were costs incurred in hiring a third-party qualified independent expert, that money would be money well spent if it ended up in saving substantial costs to ratepayers that are going to be on the hook for the entire bond issuance. And would you agree with that? That would be money well spent.
I would agree. I agree that the consulting fees, I would add to that, whether they save money or not, they add credibility sometimes and confirmation to the work that we do.
They also add transparency and accountability, don't they?
All the above.
Thank you, sir. No further questions.
Thank you, Commissioner. Commissioner Thomas.
Thank you. Just go back to a little point that was brought up earlier, and that in connection with the regulatory liability and the cost being accrued at the weighted average cost of capital, not the average cost of debt. That would actually benefit customers because this is a regulatory liability payable to customers. Is that correct?
That is correct.
Okay. Thank you.
Thank you, Commissioner. Commissioner Carol Lee Williams.
Thank you, Chair Belzer. Good afternoon. I've just got one question. In your summary testimony, you talked about this settlement being in the public interest. Would you amplify what that means to you?
In the public interest, you know, the entire process following the statute with all the parties involved, I believe, you know, once it's through all the way to the end, the whole process advocates that. Company testimony suggested a $41 million delta net quantifiable benefits. And so, yes, I would say so.
So are you saying the $41 million is what is an example of the public interest? How this is in the public's interest?
Certainly.
Okay. Anything else? Okay.
No, ma'am.
Thank you. No further questions.
Mr. Roden, I'm back. And I just had a question. Let's see. On page 5 of the settlement agreement, paragraph 8, it's the provision dealing with whether or not a utility assessment fee should be included in the calculation of ongoing financing costs. And you addressed this in your testimony, your direct testimony as well.
Correct.
And I think you quoted the statute 5827.11.15 that says that the commission may not consider the storm recovery charges paid under the financing order to be revenue of the utility for any purpose. I've left some phrases out of there, but I just read the relevant part. Why doesn't that statute control? I mean, what decision is there to be made? For paragraph 8 or provision 8 of the settlement agreement say that the commission will determine if DEP should collect a utility assessment fee and to be included in the calculation of ongoing financing costs. I don't understand the ongoing financing costs there.
Hopefully this will answer your question. I'm not sure I understand it fully, but let me.
Well, let's look at this. Okay, there's not a separate line item on the bill for the utility assessment costs. And that's basically gross receipts, is it not?
Correct.
Okay.
The gross receipt says the way you and I understand it for billing the utilities.
Correct. There's not a separate line item on the bill for gross receipts. It's embedded in base rates. Is that correct?
That is correct.
Okay. I think we're together there.
Yes.
So, but that statute that you've quoted in your testimony that says that the commission may not consider storm recovery charges to be revenue of the utility, does that not say that the storm recovery charges are not subject to the gross receipts tax?
That is ORS's position, and ORS is also position is that the commission affirmed that based on the definitions of the SPE not being a utility. And so really what the ORS is referring to is the commission's decision to affirm that which we already, believe to be true, which may be what you're saying.
Well, I'm curious as to where it says to consider that as in the calculation of ongoing financing cost. If it was going to be a true application of the gross receipts, wouldn't that be built into the base rates at some point instead of the financing cost?
Okay, thank you. These revenues from the storm recovery charge revenues are separate from revenues affecting base rates.
Okay.
So
they're not considered under that statute. They're not considered revenues of the utility, right?
That's what we're suggesting. Okay. Correct.
I think we're saying the same thing.
I think so, but I'm
missing a little bit.
I'm not sure I'm that good with you today.
I'm sure it's me, Mr. Rudd. I'm sure it's me. Okay, I just was curious about that, but thank you.
It's the storm recovery charges are not the same as base rates, and so we're recommending or suggesting that the commission makes a decision that fits what we believe the statute says, that this is not these storm recovery charges are not revenues, and that charge should not be grouped with gross receipts of the utility.
Okay, even though it's a separate line item on the bill, and there are other separate line items on the bill, but this should not be considered.
It's a separate line item on the bill that's not revenues to the utility, that is to pay back bondholders, so unrelated to utility revenues.
Okay, thank you, sir. I think you've helped me. I may have confused you, but you've helped me.
Thank you.
Commissioners, any further questions? Ms. Rainey, any redirect?
I have
You're on.
Very limited redirect.
Yes, ma'am.
Mr. Roden, earlier you indicated that you've been with ORS for approximately 4 years. Subject Chair, are you aware that ORS mission changed in 2018?
I am aware of that mission change, but not intimately aware of how that mission was accomplished prior to my being here.
Okay. And in subject to check are in the current iteration of ORS mission, as you stated earlier, is there any language that speaks to specifically to public utilities, financial viability, or economic development?
There is not.
Mr. Roden, as it relates to ORS representing the public interest, does ORS represent customers of all classes of customers?
Yes, we do.
And does ORS represent customers' right to have high quality and reliable service?
Yes.
And earlier you were asked a few questions about ORS qualification should this commission approve the settlement agreement, which and ORS would serve in the role as qualified independent third party. Is that correct?
Yes.
Okay. Mr. Rowan, you've testified earlier that ORS engaged in phase 1, for example, a consultant to help us carry out our statutory mandate.
Yes.
If ORS choose to engage some consultants to help ORS effectuate its designation as qualified independent third party, do you believe that would be representing public interest?
Yes, I do.
Thank you. I have no further questions.
Thank you, Ms. Rainey. Anything further for this witness? Mr. Roden, thank you for your testimony today. You may stand down.
Thank you.
Commissioners, we're going to need to stop for today, and excuse me, parties, everyone. We're going to need to stop for today. Tomorrow we have a hearing in another matter, and so we will resume this hearing at we have 4 more witnesses, is that correct? And then we're going to put in some stipulated testimony. Think we can get by it starting at 9:30 on Wednesday?
No objection from the company.
Okay, we'll start at 9:30 on Wednesday. Y'all have a good evening and a safe couple of days, and see you Wednesday.
Chair Belzer, before you adjourn, I just have one clarifying
Speak
question.
up quick, Mr. Robinson.
I'm happy to. So just regarding Commissioner Caston's questions previously, I just want to make sure that the company is understanding. So the attorneys are supposed to get together to discuss the roles of the ORS as well as the Department of Consumer Affairs and report back on Wednesday. Just looking for some clarity as to what that particular request was. Thank you.
In regard to securitization or just generally? In regards to securitization, the roles, and in the bond team?
Yes, Madam Chair. Not the discussion I had with Mr. Roden. I'm not trying to upset the world.
Thank you.
Thank you. We'll see you at 9:30 on Wednesday. We're in recess until then. Thank you.